The following podcast is taken from a live broadcast on Inspire FM.
Assalamu alaikum listeners, my name is Shakil Shah of Wolf & Coast Listers. Today the segment of Ask Your Lawyer show is on, and we will be discussing immigration law. So to be specific, we are discussing immigration, detention and bail procedure. Today with me we have our panelist for today. His name is Mr. Mazharul Mustafa. May I ask him, Mazharul, to introduce yourself?
Hi, nice to meet you. I'm a barrister at Church Court Chambers. I specialise in immigration law and asylum law. And good to be here today. Okay,
so this is a live show, listeners, and we will be answering your questions or queries if you have any. You can call in on 01582 481822. That's 01582 481822. You can also message in on WhatsApp at 0779 481822. That's 0779 481822. If you have any questions regarding immigration, detention or bail, feel free to contact us and we'll be able to assist you as much as we can. So the first area of immigration law we are discussing today is immigration detention. So Mr. Mustafa, what is immigration detention?
So basically, immigration detention is the detention of people in the UK who do not have the right to remain in the UK. So by immigration detention, what we mean is detention centres across the country where people who do not have the right to remain here are detained, so that either their claims can be processed or their removal can be processed.
Okay, so who can be detained?
So if we break it into two parts, firstly, if somebody enters the UK without the correct documentation or without a right to enter the UK, then of course they can be detained at the airport pending investigation. And after investigation, if it transpires that the person in question does not have the right to enter, what we call leave to enter, then that person can be taken to an immigration detention centre. The second category of people who can be detained are those who entered the UK lawfully, had leave to remain, that is, in layman's term, the right to remain in the UK, but then for some reason that right to remain in the UK, what we call in law leave to remain, expired. So they became an overstayer. And then, of course, the Home Office can detain them because they do not have the right to remain in the UK.
Okay, so we recently had a few cases where people were detained because they were overstayers or their appeal rights exhausted and stuff like that. And some of the people were actually working whilst being overstayer. Is that escalate? Does that escalate detention?
Well, you see, the answer is yes. It escalates their situation. It aggravates their situation because if they've been working unlawfully in the UK and they've been encountered by the Home Office, let's say during a raid, then the reason why I would say it would aggravate their situation is because when they apply for bail, that will be an aggravating feature which the judge will look at and which the applicant will have to deal with.
Okay, so obviously raids happen, Home Office comes across and they stop them. Do they have to give a reason why they're stopping them, or do they just carry on with their investigation?
Well, you see, of course they have to provide a reason for why a person is being stopped, but in terms of detention, what is very important to note is that the Home Office has to provide the person who's being detained with a reason for detention. Mm-hmm. So they must know why they're being detained.
Okay, and do they get asked for their documents or any evidence to prove that they actually the Home Office may be mistaken and they do have a leave to remain at that point?
Well, absolutely. I mean, the Home Office officers have a duty to ensure that they do not pick up anyone and everyone. They have a duty to ensure that they are detaining people who do not have the right to remain in the UK. And also detention, the policy is that it has to be used, I wouldn't say as a last resort, but it should be used with care. That is the policy of the Home Office. So therefore, if we have a situation where, let's say, for example, detention will not serve any purpose because less alternative means of control will serve the Home Office's purpose, then a person may be put on a reporting condition, or they might be placed with a residence condition, you see.
Okay, so I know obviously the reporting conditions come after when you get bail and stuff like that. So in terms of detention, where are the immigration people detained? Are they detained with the criminal prisoners, or are they detained separately, or how does that work?
Yeah, so if we break it into two parts, firstly, a majority of immigration detainees are detained in specialist immigration removal centres. So these are almost like prisons, but less restrictive, and they are not detained with prisoners. So these are specialist facilities built by the government for immigration detainees. Sometimes people are detained with people who have criminal convictions, and so therefore sometimes people are detained in prisons. This usually happens when, let's say, for example, a foreign national has been convicted of an offence, and after they've passed halfway through their sentence, then the Secretary of State, that is the Home Office, can detain them in prison under immigration powers. But that is only if they've been convicted of an offence for which they're incarcerated.
Okay. So I know we have come across criminal cases where people are foreign nationals, they have been sentenced, and just before they come up to the conclusion of their sentence, just before they're released, they get a removal notification. Does that always happen with the criminal convicts?
Well, you see, again, we are touching on the area of deportation. What usually happens is after a foreign national has been convicted of an offence, and they are serving their time in prison, the Secretary of State, that is the Home Office, what they will usually do is they will send that person a notice that they intend to make a deportation order against that person. Now, let's say, for example, and what that notice will say is that give us reasons why we should not make a deportation order against you. Now, let's say, for example, that person has made representations as to why a deportation order should not be made against him, and then they are given an appeal right, and then that appeal right is exhausted. After that point, the Secretary of State can make removal directions against that person. But usually what we see in these situations is that by the time the appeal rights are exhausted, either the person is in immigration detention or in the community because they've been granted bail by an immigration judge.
Okay, so in terms of normal immigration detention, say someone is arrested from a shop working illegally and then they've been taken to a detention center, how long can they be detained? Is there a time limit?
The simple answer is no, there's no time limit.
Okay.
There's nothing within the immigration rules or legislation which says that a person can be detained for an X amount of time. However, now we are going into the territory of unlawful detention. Detention must not be prolonged, and it must be for a specific purpose. That is, detention must be used for the purpose of removing a person. So the minute the purpose behind the detention ceases, detention becomes unlawful. So to answer your question, there is no specific time limit, and it has to be assessed on a case-by-case basis to determine whether detentions become unlawful.
Okay. So in terms of, obviously now someone been detained, and is there any way to get out of the detention?
Yes, there is. essentially, there are four ways by which a person can come out of detention. Firstly, is a very obvious one. Let's say, for example, they've made a claim while they've been in detention and that claim's been successful, then the Home Office will release them. The second one is by making an application to the Home Office itself, what we call a Home Office bail application. The Home Office have a form which you can fill up and which you can submit to them with supporting evidence. And if the Home Office feels that, yes, well, this person is eligible for Home Office bail, then of course they will be granted that bail. The third one, of course, is the immigration bail by a judge. So you make an application to an immigration tribunal, what we call the first tier tribunal, and then it goes before a judge. The judge will hear competing arguments and then decide whether to grant bail. If he decides to grant bail, then of course the Home Office will release them from immigration detention. The fourth one, which is a rarity, is you can actually seek bail from the High Court. But again, the High Court can only grant bail if it makes a finding that the detention is unlawful.
Okay. Yeah, so I understand there are four ways of bail, as you explained. The Home Office bail procedure, you touched upon it. Do the detainee fill the form himself, or does he need legal advice on that, or how does that work?
There's no need for legal advice. I mean, this form can be filled up by anyone. I mean, it's available online, and most of the removal centres have online facilities. So detainees can access the internet from the detention centre. So they can download the form, they can print it, and they can fill it up themselves. It's advisable that a solicitor is instructed, because there are some nuances in the form that a solicitor might understand better than a lay person. For example, often what happens is the form is simply filled up without adequate documentation. What do I mean by adequate documentation? So, for example, if you say somebody is going to provide you with a financial condition support, that is, they will guarantee that you will abide by the bail conditions, then you have to adduce their ID, their proof of residence documentation, their proof of income documentation, proof that they have the amount of money that they will put forward if a detainee absconds. Now, these documents do not have to be submitted, but if you submit these documents in a sequential order, if it's up to date, then of course the chance of being granted bail is higher as opposed to if you do not submit these documents.
Yeah, and in terms of if you do a bail, immigration judge bail, would you still need these documents?
Absolutely. So the form, the Home Office bail form and the tribunal bail form are quite similar. So the first section of what we call the B1 form, which is the tribunal form, is the applicant's details. So the basic information: their name, their surname, first name, date of birth, their Home Office reference number, whether they have an appeal pending, whether they have a claim pending. The second segment, on top of my head, is in relation to the financial condition supporters, i.e. the people who will guarantee that you will comply with bail conditions. And then I think the third section is about why you say bail should be granted. There's a section in relation to whether the management of the bail should be transferred to the Home Office if the judge grants bail. So those are... It's quite a basic form which a layperson can fill up, but the important point to note is the supporting evidence has to be quite spot on, and that is where a solicitor will come very handy to an immigration detainee.
Yeah, in terms of doing the grounds for bail.
Absolutely, and advising on what sort of supporting documents an immigration judge would want to see.
Okay. In terms of, obviously, there are certain criteria to grant bail. What is the criteria the detainee has to meet to get a bail from detention centre?
So there's essentially, when judges consider bail applications, they're looking at two things. Firstly, is the person's removal from the UK imminent? That is, will they be either removed or deported from the UK immediately? That's the first thing that they're looking for. If the answer to that is yes, then usually the bail application will be refused. The second element that they're looking at is, will this person comply with bail conditions? In other words, will this person run away, or will he or she keep in contact with the Home Office? So those are the two criteria that the judges are balancing in determining whether to grant a person bail or not, or whether or not to grant that person bail.
Okay, so as you mentioned, they need financial condition supporters as well, in terms of the sureties, what we call sureties.
Yeah.
So who can be a surety and what's their role?
So anyone can be a surety, and bail applications can be made without sureties. However, it's advisable that a bail application has at least one financial condition supporter, i.e. a surety. And it can be anyone, but it is advisable that the person who stands as the surety is a person who is well known to the immigration detainee. Yeah. The reason why I say that is because if the person does not know certain facts about the immigration detainee, then how can that person ensure, or how can that person vouch for the immigration detainee? And if they vouch for an immigration detainee without knowing fully his immigration history, without fully knowing his circumstances, then the credibility of the surety comes into question.
Okay. So just a reminder for our listeners, we are live today for Immigration Show, and I do assist if you can call in on 01582481822. It's been 18 minutes and we haven't received any call or any message in terms of if anyone has any questions. I think we are very understanding. That's why we're not getting any inquiries. But if you do have any inquiries, feel free to call in on 01582481822. We are live on Facebook. You can comment or even send a message on Facebook, and the admin team will pick up and we can answer your questions. The panel is here, a very senior barrister who has been in immigration for many years, and he will be able to assist you accordingly. So now, in terms of sureties, we were talking about financial supporters. How much money does financial condition supporter have to advance the hearing?
Again, there's no fixed amount, but the crucial point is that the amount put forward by the surety has to be a sum which is important to that person. Just to give an example, if somebody has £10,000 in their account and puts forward only £1,000, that will not be enough, because the judge will say, okay, if this person loses £1,000, then it may not.
Yeah.
It may not lead to a. Sorry, just lame.
Yeah. Okay. So there's a caller online. So let's take the call and then we carry on with the discussion. Sure. Hello.
Hello. Assalamu alaikum.
Wa assalam.
Brother, I'm calling from Luton.
Yeah.
Yeah, my name is Ahmed Ali.
Yeah.
Yeah. I want to ask you one question. Yeah. Can I speak in Urdu?
Yes, you can. Yeah.
Okay. मैंने अपनी indefinite के लिए अप्लाई करना था.
जी.
तो मुझे 10 साल का रूट दिया हुआ है.
ठीक है.
ये मेरी 3rd year extension है अभी next month.
Yeah.
तो मैं कर सकता हूँ indefinite के लिए या कि मुझे अभी वेट करना पड़ेगा?
आपको कितने साल हो गए यूके में?
मेरी तीसरी एक्सटेंशन है, मुझे 10 ईयर का रूट दिया हुआ है।
और तीसरी एक्सटेंशन मींस 7 साल हो गए
जी नहीं, अभी 2 एक्सटेंशन हुई है ना, तो
ठीक।
तीसरी अभी मैं ट्राई कर रहा हूँ।
ओके, आपके पास 10 इयर्स रूट है। आपका कौन सा वीज़ा है, स्पाउस वीज़ा या पार्टनर्स वीज़ा? स्पाउस वीज़ा 10 इयर्स रूट। ओके, दैट्स फाइन। अभी हम ये अपने बैरिस्टर के सामने पेश करेंगे सवाल, और वो आपका जवाब देंगे आपकी कॉल के दौरान ही। So the question Mr. Ali is asking is, he's on a visa and he has his 3rd extension due, and they put him on 10 years route. Can he apply for indefinite leave to remain?
Is it possible to ask him whether prior to these 2 grants of leave to remain, did he have any leave prior to his leaves under the 10-year partner route?
हेलो अली भाई, आपको इससे पहले जो पहले एक्सटेंशन से पहले आपको क्या स्टेटस, आपके पास कोई लीव थी किसी किस्म की या वीज़ा था या नहीं?
मैं एज ए विजिटर आया था।
ओके
ठीक है, तो मुझे पार्टनर रूट के तहत मुझे 10 ईयर का वीजा दिया था इन्होंने।
Okay, yeah.
ठीक है।
Yeah, so the question is very clear. So basically, the rule under the 10-year partner route is that you have to have 10 years here with leave to remain as a partner. After you've acquired 10 years leave to remain as a partner in the UK, then only can you apply for indefinite leave to remain. So what we understand from the caller is he's had at the very least 5 years leave to remain in the UK as a partner. Unfortunately, because he's under the 10-year partner route, he can't apply for indefinite leave to remain until he has spent another, let's say, 4.5 years or 4 years in the UK as a partner. So unless he's completed 10 years in the UK with leave to remain as a partner.
ओके अली भाई, आपका सवाल उन्होंने आंसर किया है, तो वो ये कह रहे हैं कि आपको मतलब 10 साल पूरे करना पड़ेंगे क्वालिफाई करने के लिए इंडेफिनिट लीव टू रिमेन।
बहुत बहुत शुक्रिया आपका।
नो प्रॉब्लम, थैंक यू वेरी मच, आपके कॉल करने का बहुत शुक्रिया। स्टे इन टच। ओके, सो दिस वाज a call, the first call of the show, and he was answered, and I think he understood the answer. Just a reminder for the listeners, if you want to speak Urdu, Bengali, we can speak these languages and we would understand the questions you have. Or if it's not in English, we can still assist in multi-languages. So feel free to contact us on 01582 481822. That's 01582 481822. You can also WhatsApp in and we'll pick your messages up. It's 07779 481822. The number is 07779 481822. We are also live on Facebook Live, and you can also communicate with us through Facebook Live by commenting on our show, and we will pick up the queries and we will answer accordingly. So now let's get back to our topic. We were on financial condition supporters. So we were on the money aspect, how much money they would need and stuff like that. So what evidence would they need in documents to prove the money?
Yeah, so usually when it comes to the financial condition supporters evidence to confirm that they have X amount of money, it's usually 3 months bank statement, bringing it up to date to the date of the hearing. So essentially, what the immigration judge would be looking to decipher is this money genuinely held by the surety? That is what they are trying to decipher. And the way they will try and ascertain this is by looking at the entries in the bank statements and bringing it up to date to the date of the hearing. Often what we see during bail application hearings is that all of a sudden a sum of money enters a person's bank account. If that is the case, then a plausible explanation has to be provided for why that money has suddenly entered into your bank account, let's say 5 days before the hearing. If there's a plausible explanation, then that's fine. So what we usually advise clients is that there's no need to have a enormous sum of money in the bank account. what the judge is trying to find out is, are you willing to put forward a sum which is important to you, which if you lose will affect you financially? That is what an immigration judge is looking for, really.
Okay. So in terms of the job, do they have to provide their pay slips and the job contract?
Ideally, yes. I mean, they have to provide last 3 months pay slips, last 3 months bank statements, proof of ID, and proof of residence. Those are the usual type of documents usually the immigration judge would want to see.
Okay, we are just reaching the break, and we should be back in the next 5 minutes. So please get in touch and contact us on 01582481822. We'll see you on the other side. Assalamu alaikum.
You're listening to an Inspire FM podcast, making available our popular programs from our daily broadcast on Inspire FM.
Welcome back, listeners. Assalamu alaikum. Sorry for inconvenience. I think a repeat show started playing. We are back to Ask Your Lawyer show, and this is an immigration segment. And my name is Shakil Shah of Wolf and Co Solicitors. I also have panelists for today. His name is Barrister Mazharul Mustafa from Church Court Chambers. If you have any questions or inquiries, you can contact us through this show, or if you want to instruct Mr. Mustafa, you can do so through solicitors, or you can leave your details with the Inspire FM team, and he will be happy to assist you. Before the break, we were talking about immigration, detention, and bail procedure. We were on the financial conditions supporters and the sureties. So in terms of sureties, we already discussed the role of the sureties, what do they need, what documents do they need, and how much money should they have, and how long they should have the money for. Now, the next question for Mr. Mustafa would be, what happens to the financial conditions supporters' money?
Yeah, okay. So essentially what the financial conditioner supporter does is puts forward a sum of money, pledges to the immigration judge tribunal that if the immigration detainee absconds, then they would be willing to forfeit that money. So let me explain what I mean by that. Is, let's say, for example, the person who's in immigration detention is released on bail as a result of a judge granting him or her bail, and then what happens is, for some odd reason, that immigration detainee absconds. Yeah. Then what will happen is a forfeiture hearing will be called upon. So the financial condition supporter will be sent a notice asking them to attend a hearing. And at that hearing, a judge will decide, was the immigration detainee running away, i.e. absconding, the fault of the financial condition supporter? And if the judge concludes that this was the fault of the financial condition supporter, then only will that money that has been pledged will be taken away from the financial condition supporter. So therefore, at the outset, the financial condition supporter does not have to give away that money. It is only if the immigration detainee runs away and it is found by a tribunal that it was as a result of the financial condition supporter's fault that the immigration detainee ran away, then only will that money be taken away from the supporter.
Yeah, we always get questions regarding being a financial support or surety, and people are very reluctant and scared of as to what will happen to them if they provide, say, accommodation and financial condition for a person who is liable to be detained and he's in detention center and they're applying. And what is the worst case scenario? What can happen to them apart from money?
There's two things here. Of course, money could be lost, Secondly, lying in court is an offence.
Yeah.
So if it is not a genuine case, and you've just been asked to stand up as surety for a person you do not know, and as a result of your lack of knowledge of that person, you have to lie in court, then of course that's a criminal offence, and that could lead to a conviction. So the advice that we give is that people who know the person in immigration detention and can speak truthfully about that person in court should stand as a financial condition supporter, i.e. a surety.
So in terms of being a financial supporter, do they have to be family members or friends, or what category of the people?
It can be anyone. The basic requirement of that, again, there's no requirement. There's no requirement as to the number of years you must have known the person in detention. There's no requirement that they must be blood related. All that is required is that the person who's standing as a financial condition supporter knows the person in immigration detention and knows basically the basic facts about that person, how he entered the UK, his immigration history, and how he knows, importantly, that this person will comply with the bail conditions, and how he knows that this person will listen to the guidance and the advice of the financial condition supporter. By this, what I mean is that, let's say, for example, the person in immigration detention centre is released as a result of a immigration judge bail, and then he comes home and lives with the financial condition supporter, and then he says to him, I feel like running away because I don't have a claim, I don't have a viable claim. At that stage, if the financial condition supporter says to that person, well, look, do not run away, exhaust your remedies, and then after you've exhausted your remedies, if it is a negative outcome and if there's no further remedy that you can exhaust, then go back to your country of origin. If that advice is not heeded by the person who's been released from detention, then really it is questionable as to whether that person should stand up as a financial condition supporter.
So in terms of stopping someone from absconding or breaching a bail condition, how much can a financial support or surety do to ensure that this person would not breach bail?
Well, this is a standard question that financial condition supporters are asked at a tribunal hearing. Again, there is no fixed answer to this, but I would say common sense should apply. If, let's say, for example, a financial condition supporter fears that the person might abscond, then they should take adequate precautionary measures. For example, ensure that if they have to report to a reporting centre, take them to that reporting centre. If they're not able to do that, and if they fear that the person might not report on their own accord, get someone else to take them to the reporting centre. If, let's say, for example, they are required to stay at a particular place, what we call a residence condition, then ensure that that person stays at that place during the night. If they abscond, then there is a duty on the financial condition supporter to contact the authorities to notify them that, look, I was the financial condition supporter for this person. Unfortunately, despite my advice, this person has absconded. So therefore, I'm notifying you, and can you take the necessary measures to apprehend him and then detain him?
Okay, so they need to take reasonable steps.
Absolutely.
They need to try to make sure that this person does not abscond, and obviously, despite saying that if he still chooses to abscond, then it's on his own accord.
Absolutely.
Okay. Yeah. So in terms of accommodation, obviously sureties are called in court when they go for a hearing, and in terms, do they have to provide the accommodation, or how does the accommodation work?
Again, for bail applications, there's no hard and fast rule that you have to provide an accommodation, a stable accommodation. However, if an immigration judge sees that the bail application form does not have a stable accommodation, then the chances of bail being refused are quite high. However, I say this with slight caution, because this might then mean that people who do not have accommodation because they're destitute or they don't have a strong connection of people in the UK might be discouraged from applying for bail. In this situation, if you're destitute and you do not know anyone in this country, or you do not have strong ties with someone in this country who might be willing to provide you with accommodation, then still make the bail application. And then during the bail application, usually the solicitor or the counsel who appears for you will make the argument that, look, this is the reason why this person has not been able to provide an accommodation, a stable accommodation, a stable address. And what they will argue then is that grant the bail in principle. If he's able to secure accommodation, then he will provide the accommodation details, and then the Home Office can release them. Or alternatively, if it is because of destitution or because they don't have strong ties with a person in the UK, then what it could be argued in court is that the Home Office should provide them with some sort of accommodation. Now, in terms of asylum seekers, there's what we call a Section 4 support. But if it's a normal human rights claim, a person who's relying on the human rights, then of course Section 4 support cannot be applied for, you see. So basically what should be done is a decision has to be taken as to whether a bail application should be proceeded with. If a bail application is proceeded with, and the reason why, let's say for example, there is no stable address is because they're destitute or because they don't have strong ties with the person in the UK who's willing to provide them with accommodation, then still go ahead with the bail application. Try and persuade the judge that bail should be granted in principle, and if he's able to be provided with accommodation by the Secretary of State, then of course he can be released. Or in the meantime, if he's able to find accommodation, I don't know, maybe from a charity or something like that, then you can provide that to the Home Office, and because bail is granted in principle, the Secretary of State, of course, then can release him or her from detention, you see.
Okay. So in terms of accommodation, obviously you answered the question in terms of accommodation. Then the bail conditions. What bail conditions can they put on a detainee when he's released on bail?
The current bail conditions that the judges follow, which can be found on the internet, states that not too many bail conditions should be imposed. Bail conditions should be kept at a minimum. The usual one that we see is the reporting condition, that after they're released on bail, they should report to a Home Office reporting centre or a police station if there's no Home Office reporting centre in the area at a specified time and date. After that, what would usually happen is the management of the bail will transfer to the Home Office, and then the Home Office will keep on that reporting condition either on a weekly basis or a fortnightly basis or a monthly basis. That's the standard condition that we usually see. The other condition that is often imposed is a residence condition. That is, the person must live and reside at a specified address. Also, there could be, and in terms of people who have overstayed and who are illegally in the UK, there is the condition that they're not allowed to work or engage in any form of education in the UK. So those are the three types of conditions that we usually see. And then, of course, there is the condition that, the sureties will pay X amount of money if the person who's detained is released absconds, you see.
Okay. So I know we obviously, but in some cases we come across where they suggest electronic tagging on monitoring. Usually we do see in criminal cases where the people are released from criminal convictions on license, they get electronic monitoring. But now there is something which come to light that they actually can give immigration detainees bail on the terms to be abide by electronic monitoring. Have you come across that? Or?
I have, but in immigration cases, this is a rarity. Usually, the reason why it is a rarity is because of a resource issue. it can be imposed, and often what we say that a person should be released on bail because he agrees to be electronically tagged, and if he agrees to be electronically tagged, then of course that offsets any risk of absconding. But however, it's not usually imposed. It's not a usual thing that is done in immigration cases, like the way that it is done in criminal cases.
Okay. So in terms of the actual hearing, when we have a hearing at tribunal, obviously both parties attend, the sureties attend, the client is produced in person or via video link. So how does that work, like a procedure of the actual hearing?
Of course, if there's financial condition supporters, then of course they attend the hearing. Firstly, the applicants' legal representatives present the case. They make the arguments as to why bail should be granted. Then usually what happens is the Home Office legal representative will make the case as to why bail should be refused. Some judges then proceed to make a decision on principle. Okay, we looked at the facts, and on the facts I'm inclined to grant bail or refuse bail. And then what happens is, if the judge is inclined to grant bail, then he or she hears from the financial condition supporter, and then the credibility of the financial condition supporter is assessed. And if the judge is satisfied that the financial condition supporter is credible, then bail is granted. Some judges do it differently. What they do is they hear everyone first, including the financial condition supporter, and then make a decision. Others can grant bail even without hearing from the financial condition supporters.
Okay, I think we are getting a call. Hello, assalamu alaikum.
Hello, assalamu alaikum, brother.
Walaikum salam.
My name is Jamal, and I have quick two questions related to immigration.
Yeah.
The first one is related to my spouse. I'm a British citizen, and my spouse was granted a spouse visa almost a year ago.
Yeah.
But that was after a long challenge with the Home Office. They made a lot of mistakes. We had to go through tribunal court for an appeal, and we waited about a year to get an appointment, and at the end, just 5 minutes before the hearing, the Home Office apologized and sent only a fax to say they withdraw their reasons.
Okay.
So it delayed her so much to get her spouse visa. And before we applied to that, she had also almost 2 years on visitor visa, because we applied and we were granted that when we were abroad. So she's been in the country for almost 5 years. My question is, can she, based on the length of time, apply directly for indefinite leave to remain rather than an extension for a spouse visa, especially considering the mistakes and the lengthy process we've been through?
Okay.
Okay, that's the first question. The quick question after that is related to the new, I'm not sure it's new or not, but it's related to the entrepreneur visa. I understand there is a threshold on entrepreneur visa if the entrepreneur has invested about 50 grand and they worked and proved they do have an active trade with paying tax, that they might apply then to extension or certain work permitted visa.
Okay, that's fine. I'll put your questions in front of my panelist and he will be able to answer you. Thank you very much for your call, and you can tune in to listen to your answers. Is that okay?
Jazakallah khair. Thank you very much. Thanks a lot.
No problem. So as you heard the call, so the first question was his wife has been on spouse visa for 1 year. Before that, she was on a visitor visa and different routes of visa, but they obviously Home Office made a lot of mistakes and it delayed her stay. Now she's in the UK for 5 years, so he's asking if she can apply for indefinite leave to remain.
My answer would be no, she can't apply for indefinite leave to remain. I understand that the Home Office perhaps have made mistakes, but the caller's wife is unfortunately confined by the immigration rules, and in particular Appendix FM of the immigration rules. What Appendix FM of the immigration rules makes quite clear is that in order to get settlement as a spouse under the 5-year route, you must have lived in the UK with leave to remain as a spouse for 5 years. So the probationary period is 5 years. And in this case, what we have is out of that 5-year probationary period, the caller's wife has only had leave to remain as a spouse in the UK for a year. So therefore, she has to, unfortunately, spend another 5 years, another 4 years in the UK as a spouse, and then she will be eligible to apply for indefinite leave to remain as a spouse under the 5-year partner route.
And if she reaches 10 years before completing this 5 years?
Yeah, so again, if she has had 10 years lawful continuous residence in the UK, then of course she will be able to apply for indefinite leave to remain under that route. But again, gaps in residence have to be looked at. Also, time spent outside the UK has to be looked at. So there's a variety of factors that would have to be looked at before it can be said concretely whether or not she would qualify under the 10-year continuous lawful residence route.
Okay, and I hope that answers your question, Mr. Jamal. Now, the second question he's asked about entrepreneur visa, where he's saying if they have an active business and they spend 50,000 in the UK, can they get a visa? Because I know it's off topic. And
the simple answer to that question is there's been a lot of changes in relation to entrepreneur visas. The previous scheme has been suspended, and so there's a new scheme in place whereby firstly the business concept has to be approved by a body appointed by the Home Office, and if they approve the business concept and the business plan, then of course they can apply. But again, they would have to meet the financial thresholds, the investment threshold. And the recent statistics shows that the number of applications under that route is at an all-time low. So I think what the caller is referring to is the old scheme that was in place. There's a completely different scheme in place now.
So yeah, in terms of second question, as Mr. Mustafa answered, that there is the scheme has been changed, so the 50,000 investment is not applicable anymore. However, there is a new is a startup business
absolutely, yeah. Startup and I think it's innovator.
Yeah, startup or innovator, which means startup is basically if you want to start a business, you have to get endorsed by a Home Office body, which is obviously accredited by Home Office, and if they endorse the business saying this is a new business as qualifies, then you get on to the application stage. And in terms of innovator visa, that is if you come with an idea, with a new innovative idea where you can, it still has to go through the bodies.
Absolutely.
Okay, so in terms of the bodies, do they have a list of the bodies? Or
so it's all... So there's a list online on the UKBA website, and it has all the procedures. But again, before one makes an application, they would have to seek advice from a specialist in this area. Otherwise, the chance of the application being successful are quite low.
Yeah. Okay, so I think the answers, the questions were answered in very detail, and then we obviously touched up on the innovative visa. So today's show was based on immigration, detention and bail, and then we went off the topic due to some questions in relation to spouse visa and indefinite leave to remain, which were answered by Mr. Mustafa. We are nearly towards the end of the show. Just a recap, this show was about immigration show regarding detention, bail, and the question related to bail. if anybody has any questions, we are obviously towards the end of the show. We will be obviously closing the show soon. So if you do have any questions, you can call Inspire FM on 01582481822, and the inquiries will be passed on to us, and we can assist you accordingly. You can leave your number, name and number and details, and we will get in touch with you in our own office times. So it's only 20 seconds left, so I'm just lost for words. So this is Shakil Shah of Wolf and Co Solicitors, and we have a barrister from Church Court Chambers. His name is Mr. Mazharul Mustafa. If you do need to instruct us, you can do, and our details are with Inspire FM. Thank you very much for listening to this show. Assalamu alaikum.
Thank you for listening to our podcast. We stream our daily broadcast on inspirefm.org. You'll find all our daily updates on our social media at Inspire FM Luton.